My name is Lisa Ezel, and I'm the Vice President for the Federalist Society's Lawyers Chapters. We're so excited to be back here at the library once again, and we're looking forward to a really robust discussion today on our theme of the First Amendment and free speech. We've assembled some very thoughtful panels with the help of our volunteer leadership here with our Western chapters, and we have some topics today touching on commercial speech, campus speech, and political speech. And we're going to conclude with a roundtable discussion on free speech absolutism. I know many of you are return visitors to the Reagan Library and to this conference, but we want to invite you to spend some time revisiting the museum and the spectacular grounds of the library. And due to popular demand, we have left some time to see the library after the final panel, and then we'll invite everyone to join us in fellowship for a closing reception at the Air Force One Pavilion. With that, I'd just like to welcome our panelists on the First Amendment and commercial speech, and I will introduce our moderator, Christina Sandifer. Christina is Executive Vice President of the Goldwater Institute, where she develops policies and litigates cases advancing healthcare freedom, free enterprise, private property rights, free speech, and taxpayer rights. She's a co-author of the book, Cornerstone of Liberty, Private Property Rights in 21st Century America. She's a frequent guest on national television and radio programs, and her litigation and policy work has been featured in National Review, The Washington Post, Human Events, The American Spectator, and The Weekly Standard, amongst other publications. She is a graduate of Michigan State University College of Law and Hillsdale College. With that, welcome, Christina.
Thank you, Lisa, and thank you all for coming. We're going to start out talking about commercial speech. So you can all pull out your constitutions that I know good Federalist Society members always keep in your pocket. And if you do that and you look at the First Amendment, good, hey, we actually do have them. I love it. I love it. If you look at the First Amendment, you see that on its face, it makes absolutely no distinction between types of speech. Certainly there's nothing in there about commercial speech. And yet courts have often called commercial speech something different, and they've treated commercial speech different, affording it oftentimes less protection than other types of speech, such as political speech. Now, this distinction roughly dates back to the Progressive or New Deal era, and at that time, when courts started affording less protection to commercial speech, we saw a shift from the founders' view that speech ought to be protected because it's an individual right. And a person owns himself and his own beliefs, and so he ought to be free to speak those beliefs. We shifted from that to a more of a progressive view, right? That speech isn't a good in and of itself, but speech is good for society, and we ought to protect speech only insofar as it's beneficial to society. And if it's not beneficial to society, then perhaps government has a role in regulating that speech. So today, what we've ended up with is this hodgepodge, really, of precedent out there. And where commercial speech is involved, courts oftentimes will balance the interests of the speakers against those of the regulators. Now, to be sure, this commercial, non-commercial speech distinction has drawn criticism from judges and from legal scholars over the years, especially recently. And one of the reasons for that, of course, is that when you divide speech between commercial and non-commercial, you're making a content-based distinction. And of course, the court has said many times that regulators ought not regulate speech based on the content, based on the message or based on the speaker. And what is a commercial, non-commercial speech distinction but a content-based distinction? And also practically, it's very difficult to make a distinction between what type of speech is commercial and what type of speech is not commercial, say political. For example, newspapers, right? Oftentimes newspapers have editorial boards that will talk about political issues. Sometimes they even endorse candidates that are on the ballot. And so is that speech political, and thus does it deserve the highest form of protection? Or is it commercial because the motivation of the newspaper is to sell newspapers? So is it commercial and then afforded lesser protection? It's a difficult line to draw, and yet it makes all the difference in the world in these cases because it determines the type of protection that speech will get afforded if a regulation is challenged. I would argue also that this is a dangerous distinction to make in some areas because it sometimes is used to silence truthful speech. So, for example, the federal government limits the way that pharmaceutical companies can provide truthful scientific information about their lawful products to doctors, to patients, to insurance companies. This is the off-label speech gag rule that many of you might know about, right? This is the FDA allows treatments that are FDA approved but used for other purposes or perhaps other dosages or patient populations. It allows doctors to treat using those medications, but it doesn't often allow pharmaceutical companies to share scientific information about those treatments. And so we have a very odd situation where not only are we suppressing or outlawing truthful speech, but we are actually allowing the underlying conduct but prohibiting the speech, when oftentimes it's the other way around. The speech itself is protected and the conduct may be outlawed. So all of this makes for a very muddled jurisprudence, but this may be changing. The Supreme Court has recently confirmed that speech for commercial purposes is protected, and there are real limits on the government's power to regulate that speech, again, based on content. But all of that is sort of getting fleshed out. The Supreme Court has also recognized that state constitutions that all have their own unique protections for free speech, they can be interpreted differently than the federal First Amendment. They can be interpreted more broadly and to be more protective of rights than the First Amendment. So what does that mean for commercial speech? Do courts at the state level draw distinctions between commercial and non-commercial speech, and do they need to? Where does that leave us today? Is the Central Hudson test, the test that treats commercial and non-commercial speech differently, flawed? Does the commercial-non-commercial speech dichotomy encourage government abuse? Or do we need to maintain some sort of distinction here? Is it important to look at commercially motivated speech differently from politically motivated speech? Essentially, what I want to discuss today is what limitations should courts permit government to impose on commercial speech, if any? And to answer those questions and others, we have a great panel of distinguished speakers for you today. I'll briefly introduce them. I've asked them each to provide about 15 minutes of their initial presentations, and then we'll turn it over for commentary and questions. And ironically, my job as moderator today will be to suppress all of your speech if you go over that 15-minute mark. First up will be Bradley Benbrook. Bradley Benbrook is the founding partner of Benbrook Law Group. Before starting the firm, Brad was a partner for several years at Stevens & O'Connell LLP, Sacramento's premier litigation firm. After graduating from Bolt Hall School of Law at the University of California at Berkeley, Brad worked as a judicial clerk on the United States Court of Appeals for the 11th Circuit in Atlanta. Brad has litigated in state and federal courts at the trial and appellate level throughout California. His notable litigation includes a successful defense of State Farm in an action by then Attorney General Bill Lockyer's office to invalidate settlement agreements following the Northridge earthquake. In the 2012 election cycle, he defended a donor in high-profile litigation over the alleged violation of state campaign finance regulations, and he has also successfully defended a number of companies in actions brought under the California Political Reform Act. Next, we have Eric Jaffe. Eric Jaffe is an appellate litigator with a practice covering a wide variety of legal issues in both state and federal courts of appeals. A substantial portion of Mr. Jaffe's practice focuses on constitutional issues and litigation in the United States Supreme Court. He represents individuals, business corporations, and nonprofit organizations who are parties in litigation or who seek to participate as amicus curiae in cases presenting significant economic, political, or social issues. Mr. Jaffe also collaborates with other law firms and lawyers seeking to supplement their litigation resources. At the trial level, he consults with and assists primary counsel on significant issues and motions, providing an appellate perspective and helping to frame the legal issues for any potential appeal. And then finally, we have Amanda Shaner. Amanda Shaner is a PhD in law candidate at Yale. Her research focuses on constitutional and administrative law, speech and association, and their intersection with the behavioral sciences. A graduate of Yale Law School and Yale College, Amanda served as a law clerk to the Honorable Cornelia Pillard and Judith W. Rogers of the D.C. Circuit and Robert W. Sweet of the Southern District of New York. She has a background in constitutional litigation and social movement strategy. With Professor David Cole, she litigated a number of constitutional and national security cases while a fellow at Georgetown University Law Centers on the national security and the law. Previously, she served as the U.S. Program Officer at the Robert F. Kennedy Center for Human Rights. She is the co-author of Counterterrorism Law and has authored articles on the First Amendment, constitutional change, and the administrative state. Thank you all for joining us, and with that, Brad.
Thank you, Christina. Thank you all for coming today. If you looked at the original lineup for this panel, you would have seen that Judge Alex Kozinski was going to play a starring role. Alas, you show up early on a Saturday morning and you get me instead. I am the switch in Bait and Switch. But Judge Kozinski is with us here in spirit today. As Christina indicated, commercial speech is given less protection by the courts than basically every other form of speech. And in 1990, Judge Kozinski wrote a very influential article titled, "Who's Afraid of Commercial Speech?" The point of his article was to question why there should be any distinction between commercial speech and any other type of speech. He notes, as Christina noted, the First Amendment just says Congress shall make no law abridging the freedom of speech. It doesn't say some speech is more valuable than others, but that's the premise of the entire doctrine, that in fact commercial speech is less valuable. Judge Kozinski notes in his article that in 1942, in a case called Christensen, the Supreme Court just announced all of a sudden that commercial speech is less protected. It said, "We are clear that the Constitution imposes no restraint on government as respects purely commercial speech." The court cited no case for this supposedly clear rule. Starting in the 1970s, however, the court acknowledged, well, you know, maybe we overstated it a little bit. The First Amendment does provide some restraint on the government's ability to regulate commercial speech. In 1976, in a case called Virginia Board of Pharmacy, the court struck down a ban on advertising prescription drug prices. And the opinion analyzed the constitutional problem in language that reflects two very different attitudes and visions that are difficult to reconcile within the same majority opinions. On the one hand, the court looks down its nose at commercial speech. Now keep in mind, at the time, this was the groundbreaking pro-commercial speech case, but the court said, advertising, however tasteless and excessive it sometimes may seem, is nonetheless communication. It's communicating some information to the marketplace, so we should give it some protection. In a footnote, the court added, well, it's common sense that commercial speech will be subject to less protection than regular speech. The court claimed in this footnote that because commercial speech is for profit, it's supposedly more durable than regular speech, meaning, I guess, that it's less likely to be deterred or chilled by regulation. But in various ways, the court's basically saying for-profit speech, advertising, is just grubby and not as valuable as other kinds of speech, and that's the end of the story. On the other hand, actually, it's not the end of the story. The court, in the same opinion, rejected the state's arguments in favor of the regulation as too paternalistic. The state tried to justify the ban on advertising prescription drugs by saying, well, if pharmacies are allowed to advertise their prices, then customers will just go to the lowest price pharmacy, and high-quality professional pharmacies will suffer. And that's ultimately bad for the public. In other words, the sponsors of this legislation didn't want pharmacies competing on price by advertising prices in order to keep drug prices high. The court said, no, this is just basically paternalism, and people should be trusted to make their own decisions. In a famous passage, the court said, the choice between the dangers of suppressing information and the dangers of its misuse, if it's freely available, is a choice the First Amendment has already made for us. 4 years later, in 1980, the court developed a sort of hybrid intermediate scrutiny test in the Central Hudson case, but it didn't resolve the basic conflict of the two competing views I just described. Now, it's important to note, just to set the table for the commercial speech that will be doctrine or regulation that we're talking about here, it only applies to truthful, non-misleading speech about lawful activity. In other words, First Amendment isn't implicated by consumer protection laws that ban false or fraudulent misleading speech. First Amendment isn't implicated by laws advertising sale of heroin, for example. You can't do that. So under this test, Central Hudson test, a regulation can be upheld if it serves a substantial state interest, the regulation directly advances the state interest involved, and it's not more extensive than necessary. Now compare to strict scrutiny the familiar test that would apply to any other content-based regulation. Superficially, they're pretty similar, but of course we know strict scrutiny generally makes it impossible for a speech law to be upheld, a speech restriction. One of the main differences between the two tests, the state interest involved in the Central Hudson test, a substantial state interest, allows more paternalistic objectives, police power type objectives to qualify as substantial interest, which is, I think, one of the key differences. Now, Central Hudson has been criticized and questioned repeatedly by multiple members of the court, but it's still with us. It's almost like a placeholder, opinion after opinion. The majority opinion will say, well, a lot of our members don't like this test, but we're going to apply it anyway because we haven't really come up with a better solution. Two of the leading judicial critics of this test are Judge Kasky and Justice Thomas. And one of Judge Kaczynski's main critiques is that the for-profit nature of speech shouldn't make a difference in the amount of protection that is given. As he points out, everyone knows that the New York Times and the Washington Post try to make a profit, yet their for-profit work enjoys the highest level of protection. Why does it follow that it's better for-profit speech? If the profit motive mattered, then volunteer political speech would be entitled to the highest protection rather than for-profit political speech. Judge Kaczynski likewise asked, why is it supposedly common sense that advertising occupies a lower class of speech than, say, for-profit artistic speech? He notes that a lot of art and creativity go into TV commercials, for example. We'll see that next week at the Super Bowl. Commercials often build goodwill by creating positive vibes along with the product. They put a lot of effort into simply entertaining us, making us laugh. Yet we can't fathom the government putting content restrictions on other short forms of entertainment. In more recent years, Justice Thomas has taken the lead in questioning why commercial speech is given less protection. In 1996, in a famous concurrence in a case called 44 Liquor Mart, Justice Thomas starts from the proposition that the essence of the First Amendment is to prevent government's paternalistic impulses to shield citizens from the truth, straight out of the second half of the Virginia Board of Pharmacy case I just mentioned. Justice Thomas says when government's aim is to keep legal users of a product or service ignorant in order to manipulate their choices in the marketplace, no balancing test should be used, and this supposed government interest should be considered per se illegitimate. There he goes again, not telling us what he really thinks. But alas, the court hasn't adopted that view. But commercial speech regulations have not fared well since his opinion in 44 Liquor Mart. Indeed, it's interesting to note that things have worked out pretty much the way Justice Rehnquist predicted they would in his dissent back in 1976 in the Virginia Board of Pharmacy case. He said, in classic language that really sets the stage for the competing judicial views, He said that opinion elevates commercial intercourse, which is an interesting expression, between a seller hawking his wares and a buyer seeking to strike a bargain to the same place as has been previously reserved for the free marketplace of ideas. Now, he worries, the way will be open for active promotion of prescription drugs, liquor, cigarettes, and other products, the use of which it has previously been thought desirable to discourage. And he was right, thankfully. So in that light, I'd like to move to a current example of a commercial speech case that I'm working on. Back in 2014, I got a call from Brandon Combs, who is the executive director of a group called the Cal Guns Foundation. It's a group that advocates for Second Amendment rights in California. Brandon told me that one of their members, a retail firearms store, had been cited by the California Bureau of Firearms for violating a statute that prohibits firearms retailers from advertising on site the fact that handguns are available for sale there. And I said, there must be some misunderstanding. There can't be a law that says that. And sure enough, there is. Penal Code Section 26820 prohibits firearms dealers from displaying a handgun or imitation handgun or a placard advertising the sale or other transfer thereof in any part of the store where it can be readily seen from the outside. So, for example, you can't have a sign with a big picture of a handgun. That's the sign on the wall, was the sign on the wall at Tracy Rifle. You can't have a sign with a small picture of a handgun. That sign had been standing outside the store of Imbert and Smithers for decades. While this law was on the book, this law was passed in 1923, but apparently was rediscovered by the Bureau of Firearms in about 2013 or 14. You can't have a sign that mentions handguns, period. But you could have a sign that says this, flashing neon sign. If that sign said handguns, handguns, it would be illegal. You'd lose your license, and if you refused, face a misdemeanor. In true First Amendment spirit, however, one of the retailers affected by this sign decided to protest, and over the handgun wrote the word censored. So with the support of the Cal Guns Foundation, I'm co-counsel along with Eugene Volek for a group of retailers challenging this ban. Brandon Combs from Cal Guns Foundation is here with us today. I'd like to recognize him and thank him for supporting this case and supporting other First Amendment cases. Without financial support like that, many of these regulations just get used and don't ever get challenged. Now, this to us seems like a particularly good case to promote the anti-paternalism argument that government shouldn't be able to shield us from truthful information, because handguns are not just a lawful product, they're a constitutionally protected product. At the preliminary injunction stage, the state initially tried to defend the case by saying this ban is a good thing because it discourages impulse purchases of handguns. And we pointed out, in California, there's already a 10-day waiting period before you can buy a handgun. There are no impulsive purchases in California. The state retrenched, thought about it. I said, well, no, that doesn't matter. The signs will still appeal to people with impulsive personality traits who shouldn't be encouraged to have guns, because once they have them, they're more likely to commit suicide if they're impulsive people. So by this way, they sort of reverse engineer the state interest into trying to fit the rest of the Central Hudson test. But as for application of the other Central Hudson factors here, there are several problems, but we just note how under-inclusive the ban is. It only applies to on-site advertising. It doesn't apply to internet advertising or any other form of advertising, so it can't directly and materially advance the asserted objective. There's no happy ending to this story yet. The court denied the preliminary injunction motion. It said, well, plaintiffs, you are likely to win on the merits, but because this case involves guns and public safety, I find that the equities don't tip in your favor, so I'm not going to grant the preliminary injunction. And that was brought to the Ninth Circuit and affirmed and brought back down. Summary judgment papers were filed roughly a year ago, almost exactly a year ago, still waiting for a decision. But this case is a reminder that unless and until commercial speech is treated the same way as other types of speech, paternalistic impulses will always tempt government to use speech restrictions as a way to deter conduct it doesn't like. Thank you.
Hello and welcome. I just realized through Brad's speech that we share a client, which is the Cal Guns Foundation. The difference being, of course, I view this differently because I'm doing a Second Amendment case for them. I think that Brad even worked on at the trial level and won, by the way. I'll probably lose at my level if I had to guess. But I would have interpreted that story as California's hostility to guns, not to speech, because if it was speech they liked, they would have applied the Central Hudson test faithfully, and any coherent version of the Central Hudson test would easily strike this down without even a pause. So I don't view it as much as a speech doctrine problem as the Ninth Circuit can't stand guns. And I'm sorry if there are Ninth Circuit people in here, but I've been incredibly insulting to the Ninth Circuit recently and plan to continue because... So with apologies for that, we'll talk about that later. But that's my First Amendment view of it. I'd actually find it to be an absolute miracle if courts applied actual intermediate scrutiny, the Central Hudson test in its true form, in its otherwise applicable form, in lots of cases, including in speech cases, by the way, but at least in gun cases, because Central Hudson is actually quite vigorous. I have less of an issue than Justice Thomas does with Central Hudson if it is applied in a sensible way. I have some alternatives that I'll propose, but let me step back for a moment because I want to get there in a somewhat roundabout way. The case I sort of had said I was going to talk about today, and I'd like to talk about today, is this big case that wasn't. It's a case called Nike versus Kasky, which happened in the 2003, I guess, is when it hit the Supreme Court. 2002, when it was decided in the California Supreme Court. And for those of you who don't follow dead cases that made no difference in the world. I'll describe it briefly for you. If you may recall, back in the late 1990s, Nike came under fire for its labor conditions abroad, where its shoes were manufactured in Vietnam, Indonesia, and China, that they were paying them poorly, that the working conditions were terrible, et cetera, et cetera. And there were ABC News reports and CBS News reports and newspaper articles and op-eds lambasting Nike for their terrible corporate citizenship, basically. And Nike, not surprisingly, defended itself and said, no, we pay them better, we do well. They made all these assertions about their business practices abroad. They made these assertions in op-eds, in paid advertisements, in papers, in letters to athletic directors and schools, defending themselves. And as a result of these letters, an intrepid advocate, Mr. Kasky, sued them under a statute in California that at the time allowed private attorney generals to bring suits on false advertising and unfair competition claims. And the allegation was Nike's statements were false, that what they said about their behavior was untrue, and consequently they should be held liable, and in fact should be forced to have corrective speech if it was found that they were false. So they would have an injunction actually forcing them to say the opposite of what they said if they lost. And California law at the time had laws against unfair competition, which included unfair, deceptive, and misleading advertising. It also had a false advertising statute that applied to untrue or misleading advertising that the speaker knew or should have known was inaccurate. So basically a negligence standard. And for those of you who are familiar with First Amendment, in the normal political realm, let's say political speech, New York Times v. Sullivan requires actual malice, at least on issues of public concern or public figures. And I think the Nike issue is obviously that. So the debate really in this case was, do you apply a negligence standard or even a strict liability standard, arguably, for false statements in commercial speech, if what Nike was doing was commercial speech, or do you apply the New York Times v. Sullivan standard, which is a knowing falsehood standard, an actual malice standard, if it's not commercial speech. And the whole fight went through the courts on that one question: is this or is this not commercial speech? With everyone understanding that that was ultimately that was probably a dispositive issue. If it was not commercial speech, Nike wins. Kasky conceded that. He conceded he couldn't meet the New York Times v. Sullivan standard. If it was commercial speech, Nike might win anyway if you applied Central Hudson in a decent way. Potentially, or their speech may not have been false. They might have just won on the facts, or on negligence, saying we made good faith efforts to find out and we did our best. But at a minimum, Nike demurred, saying Central Hudson doesn't apply, New York Times v. Sullivan applies, we win. Nike wins in the trial court. Nike wins in the intermediate appellate court, California state courts. Nike loses 4-3 in the Supreme Court of California. With Justice Kennard writing the majority opinion, Justice Chin writing the principal dissent, and Justice Brown writing her own separate dissent at the time, each arguing why it was or was not commercial speech, and it all turned on the U.S. Constitution. They sort of said, yes, the California Constitution is here, but it follows the U.S. Constitution on this question, even though the California Constitution on free speech is often broader than the First Amendment. On the particular categorical question, they said it would be identical. So this goes up for cert to the. Oh well, let me back up. So the rationale they gave of what constitutes commercial speech was speech done by a commercial speaker, Nike, to a commercial audience, the general public and athletic directors who buy Nike goods, about the speaker's own business operations. That was exactly what it was about, for the purpose of promoting sales of its product. And here one might imagine that that wasn't exactly the purpose, but it was certainly the purpose to prevent people from abandoning its products, because in fact Nike was suffering losses in sales because people thought they were a terrible company, who believed these reports. So according to the California Supreme Court, it fit that standard. That was the test for commercial speech. Thank you very much. And the fact that it also touched upon issues of public importance, labor practices, international trade, globalization, all of those things, while true, didn't matter. In fact, the court openly acknowledges that this is mixed speech, that it is not only commercial speech, it is commercial speech plus speech about public issues, but said it doesn't matter. And the reason it didn't matter was twofold. One is because commercial speech was, what did they say? It was more easily verified when it's about your own operations. So the fact that it also was about public issues didn't matter. And two, it was hardier. So basically what you heard about the same standards in Virginia Board of Pharmacy. More easily verified, you should know what you're doing. You should know about yourself when you're talking about yourself. And hardier, you have a huge profit incentive to speak, so we're not going to chill you very much. Goes up to the Supreme Court on an interlocutory appeal, basically, right? Because all the original decision had done was send it back for trial. The Supreme Court takes it, gets full briefing on this, 31 amicus briefs, full argument, end of the term, dismissed as improvidently granted. They dismissed the case, no decision. The dismissal, however, carried several concurring and dissenting opinions. Two concurring and dissenting opinions. The concurring opinion by Justice Stevens gave 3 reasons for making the case go away. One was 2 of them were very technical, not final judgment, no standing. The first one is sort of true, but not as a statutory matter. The second one, not really true. While Kasky wouldn't have had standing in federal court, Nike certainly should have and did. But the last reason he gave is that it's a novel question and it's premature to decide this issue on this record, which is basically the court's way of saying we're not going to jump into the briar patch and the thicket without really giving it a chance to work itself out, which is a very common thing, oddly enough, for the court to do. Normally they just deny it at the front end when that's true, but so be it. They do it at the back end. Justice Kennedy dissented without comment. Justice Breyer and Justice O'Connor dissented with comments saying they thought we should take the case, it's worth deciding, and strongly hinting that Nike would have won, if not in its full-blown version, certainly in a substantial version. And I think the arguments and most of the commentators at the time figured Nike would have won had there been a decision. So why are we talking about a case that went away, that they never actually decided? And the answer is a couple-fold. One is that since Nike, there's been just a ton of commentary on this, because it is actually a big question about what to do with mixed speech. And does it get lower First Amendment protection? The second reason is because it comes up indirectly in other contexts. And part of the reason for that is that advertising has evolved. Or maybe it's not evolved, we've just noticed that advertising includes more than a sign that says, buy my guns, buy my soda, buy my shoes. Advertising these days includes, I think it covers a broader topic of promotion. Companies don't just advertise their product, they advertise themselves. They advertise their image. If you're not a good corporate citizen, no one will buy your products. So just talking about yourself, talking about your efforts in the world, talking about your charities, sponsoring a golf tournament that gives money to hospitals is all functionally advertising. It is done by a speaker, by a commercial speaker, to a commercial audience, about yourself very often when you're talking about if you're a good corporate citizen, and we promote maternal leave, we promote equal opportunity, we have sexual harassment policies. And it is done obviously for the purpose of promoting sales. I don't think there's any question that under the Nike v. Kasky standard, all of that is commercial speech when at least it's self-referential. Maybe if you're just talking about the good of the world and other charities, it'd be okay. But if you're talking about yourself, it's at least mixed commercial speech. And consequently, everything a corporation says, to the extent it's designed for image building, let me take that back. Everything a commercial speaker says, I don't mean to say corporations, because this of course applies to the mom and pop shop that says we give to charity with, it's Veterans Day, we're going to donate some of our proceeds to charity. All of that is commercial speech entitled to lower protection, according to this California case that, by the way, is still good law and is still on the books. So that's the other reason we keep talking about it. And the problem is, a good case has not cropped up since Nike. Part of the reason for that is California there, shortly after Nike, they repealed the law that lets individual gadflies attack companies. So you can no longer have a Kasky bring a case like this. You'd have to have the state itself bring a case like this, or perhaps an injured consumer. And injured consumers face a bigger hurdle. Did you really only buy that Nike sneaker because you thought they were good citizens in Vietnam, or because you liked the Michael Jordan logo on it? Right? And I think few people have credible arguments and wouldn't waste their time bringing the claims. It's really sort of issue advocates that bring those kind of claims, and they lost their ability to do that to some degree. So why do I still want to talk about it, even though these cases don't come up a lot? And I think the reason I'd like to talk about what I find interesting, actually, is that I think the issue is less important these days than it used to be. I think the Central Hudson test has evolved to a much stronger test. And we heard a little discussion of that. And if you look at commercial speech cases, they are few and far between where the state wins. Yes, with guns in the Ninth Circuit. But I don't think of that as a free speech case. That's a gun case. Nobody likes guns in the Ninth Circuit, and so that's never going to happen. But elsewhere, and in the Supreme Court, you've had more and more protection for commercial speech and less sympathy to these made-up state justifications that have no backing at all. So for me, I find the distinction less important about how you categorize it than what do you do about speech that at a minimum is mixed, that talks about the corporate entity in a way that matters to the public, but also is obviously designed to improve your image so you can sell more goods. There's obviously a profit motive there. And I would say the following. I would not worry about it, like how I learned to stop worrying and love the bomb, right? How I learned to stop worrying and love commercial speech. I would worry about the details, particularly. And a good example of this is a case called TAM. You may have heard of it, recently came down. It's about the rock band called the Slants. It's an Asian American rock band with a racially offensive name as their title that they chose precisely to take back the slur against their ethnicity, and they sing songs dealing with that. And they were denied a trademark because it was a slur And what I find, the case is interesting on a lot of grounds. What's interesting in this context is that there was an argument that the rock band's name is commercial speech, and consequently they're not entitled to full-blown protection. And Justice Kennedy basically said, look, it doesn't matter if it's commercial speech. This is viewpoint discrimination. It doesn't matter. Call it what you want. You still lose because you can't do that. And I guess for me, I would rather get away from worrying about whether it's commercial speech and worrying more about certain basic First Amendment principles that we should adopt and apply regardless of how we categorize the speech. I think one of those principles would be the paternalism principle, which is if you're trying to manipulate, not even just deny me truthful information, but manipulate my information because you don't like the decision I'm going to make based on that information, that is not government's role. If you think I'm going to vote for somebody stupid and you want to enhance the speech of the better candidate, you can't do that. If you think I'm going to buy something stupid and you want to enhance the speech of some other product, you can't do that. The other principle that is more applicable to the Nike case, of course, is the breathing room principle, that we need breathing room for discussion and debate. And I think regardless of whether Nike's speech was commercial, if you're going to have a debate on circumstances and situations abroad that are difficult, that deal with labor topics and controversial topics, and even about Nike's own behavior, there needs to be breathing room to get the facts out there. You can't have people participate in that debate saying, if I make one error, if I make one slip up in even discussing the facts, which perhaps are knowable but are difficult to know, I'm going to get sued. No, we don't want that. The First Amendment understands that the best and simplest correction for an erroneous statement is a counterstatement. Nike says, no, we don't. And then ABC News comes up and says, well, here's the video of where you do. Thank you very much. I don't think we need the law to check erroneous falsehoods. And so I would apply that standard. Obviously, the active and intentional lie, or even the reckless lie, you could actually cover under non-commercial speech principles. So once again, there's no need for having a distinction. An active lie saying, you know, this is a genuine product from the USA, and it turns out it's not, it's from Vietnam. That's an intentional lie, presumably if you could show it was intentional, which seems to be pretty easy. I would just apply the principle and not worry about the categorization. The one other thing I'd say about commercial speech that I think addresses what is the underlying concern in a lot of commercial speech cases, which is the marketplace aspect of the transaction. And how is it that I can't regulate something that says, I'm selling you a car with 1,000 miles on it, and in fact it has 100,000 miles on it. I'm lying to you to induce you to enter into a commercial transaction. And my answer to that is that that is not speech as we traditionally understand it. That is a speech act. So when you think of offer and acceptance in a contract, I offer to sell you this for $10, I accept. Literally, those are both speech. You're engaging in speech. But it's speech with legal force. It's a speech act, and I would regulate it as an act, not as speech. And this deals with certain issues in the securities law. This deals with certain issues in false advertising, where I say I'll sell it for you for $1, but you get there and it turns out there's $50 worth of fees that they never mentioned, or whatever, what have you. And the example I give of this typically is the O'Brien case. So in O'Brien, if you recall, way back when, a guy burned his draft card as a protest. No question, it was a speech act. He was engaging in speech, but he was also destroying his draft card, which is just an act. It may have expressive consequences, but you could say, don't destroy your draft card, just like you could say, don't destroy your license plate on your car, because of the act portion of that. You need the draft card to engage in certain government behavior. You need your license plate so that we can track your car. All these things are acts, and if you regulate the act rather than the expressive content of the behavior, we generally say it's okay, so long as it doesn't excessively burden First Amendment values. And that's exactly the standard I would apply in commercial speech. You can regulate the commercial act as you need to stop fraud, to stop reliance, to stop all those things, so long as you don't unduly burden the expressive aspects of this kind of mixed speech. And I think under such a standard, we'd ultimately apply something very close to New York Times v. Sullivan, if not exactly New York Times v. Sullivan, and Nike would have won quite easily. Now, I'm going to close with just pointing out that to the extent that people really do apply Nike and don't apply an incredibly vigorous version of Central Hudson, it's an unbelievably broad standard the California Supreme Court has adopted. and technically still applies. So just imagine some current events. Harvey Weinstein says, I didn't do it, or I didn't do all of it, I did some of it, but not all of it, or I did it less than you say I did, or I wasn't chasing all the way around the room, only halfway around the room. He is a commercial speaker, talking about his own behavior in the context of movies and actresses and his behavior, much like Nike talks about his production. This is his production. He is doing it to an audience that either buys his movies or buys them from the secondary distributors. I think that works. And he's clearly doing it to preserve his business interests. Woody Allen, same thing, right? He wants people to watch his movies, and he wants producers to hire him to direct movies. I don't see how we call that non-commercial speech under the Nike v. Kasky standard. Yet, do we really want to impose a strict liability test on truth of people debating these issues in public? I understand nobody's going to stand up and defend Weinstein and Harvey, but what if it's Netflix who comes out and says, we're dumping Kevin Spacey, oh my God, he's terrible? Do you really want Netflix to be subject to a commercial speech standard for having said that? Because obviously they're saying it in a commercial context, they're saying it so they don't lose customers, they're saying it to promote sales, and it's about their own operations, how they're dealing with Kevin Spacey. Do we really want that to not be given full First Amendment protection in the sense of a mistake is one thing, but you'll get tagged for an intentional lie, but you won't get tagged for a mistake? What about defamation? What about actresses who come out and say, Mira Sorvino, who says, this is why I never got a part again, is that Harvey Weinstein, I rejected Harvey Weinstein, he's a pig. Do you want to, that's commercial speech under the Nike v. Kasky standard, I think. She's saying it to an audience that would have otherwise hired her. She's explaining that she's not an undesirable actress, she's just somebody who got blackballed by Harvey Weinstein. So it's talking about her own experiences and context and why she might not have gotten jobs. And she's doing it in the hopes of, well, vindicating the general principle, obviously, because he's a pig, but also presumably getting more acting jobs because getting off the blacklist of whatever she was put on. Those are just admittedly potentially far-fetched examples, but they're troubling because everyone in business, in any kind of business, whether you're a lawyer, whether you're an accountant, when you talk about, in the day and age of we only want to hire good people and people we like and people who reflect our values, it is almost impossible to talk about anything, about yourself at least, that is not similarly image enhancement and promotion, unless you say you fall on your sword and say, I'm a pig. Then I guess it's not image enhancement. So that's how I would end, is to say, I would be worried about applying commercial speech to self-referential statements, commercial speech doctrine or load protection to self-referential statements on the theory that it's just promoting yourself. I think that we should get away from worrying whether it's commercial or non-commercial and get back to the notion that we want breathing room, we want to be able to debate, and there actually is a difference between the intentional lie and the negligent error, and that speech doctrine shouldn't penalize the negligent error. Thank you.
Hi, everybody. Welcome, and thank you all so much for coming. It's an incredible pleasure to be here with you today. As Christina said, my name is Amanda Shaner, and I am currently a PhD candidate in law at Yale Law School. I also, which you didn't say, am an attorney in the National Litigation Department of the American Civil Liberties Union, where I work on the organization's Supreme Court docket. But I want to say, first off, these are my academic and individual points, comments, beliefs, and in no way represent the organization's official positions. But I should say also kind of relevantly, most recently, or very recently, I worked on Masterpiece Cake Shop v. Colorado Civil Rights Commission, a case involving a First Amendment challenge to a Colorado anti-discrimination law, essentially a First Amendment challenge, a free speech challenge about the idea that baking a cake is a form of expression protected by the First Amendment. And what I want to do in my short time with you today is to step back a little bit in an academic way about some constitutional history even prior to some of the questions that the panelists have engaged in, to provide a little bit of context for their important interventions and hopefully for some of the rest of the discussion today. And then I want to raise some questions for you all more than I want to make some arguments. I want to raise some questions about the implications of what we're really seeing, the shifts in First Amendment case law today, particularly with regard to economic speech. But the main thing I would like you to take away from my points is that we're really in the midst of a really big shift in American constitutional law, and there are a lot of questions about if that's a good thing or bad thing from a number of different directions, and I hope that we can see that. That's why, of course, this conference today is about the First Amendment, it's because the First Amendment today is a big deal. Okay, but first, can I ask a question? Who all are law students here? Okay, and who all, law students, have you taken the First Amendment, and other folks, do you have any background in the First Amendment? A little bit? Okay, great. Okay, so some history. So despite the fact that this panel and this conference is on the First Amendment, I think to understand where the First Amendment is today, and to really thoughtfully consider where it should go, we actually have to start long before the Supreme Court ever considered the First Amendment, and in fact not with the First Amendment at all, but instead with the 14th Amendment. As you all know, Lochner v. New York was a landmark Supreme Court precedent from the early 1900s in which the court held that a maximum hours law for employees violated the Constitution. Lochner's come for many, but not all folks, to symbolize the judicial striking down of economic regulation during the Gilded Age and Great Depression, and the court's understanding that the Constitution protects a pretty robust understanding of economic liberty under the substantive due process. Lochner is often heralded as part of the anti-canon and used by progressives and conservatives alike as a pejorative for judicial activism, but we might question how just that assessment is. Justice Roberts, for instance, in his dissent in Obergefell, the gay marriage case, accused the majority of Lochnerism in its recognition of marriage equality. But I should say, as I hope we'll discuss here, there's growing voices, particularly in the conservative legal community, about whether or not the 14th Amendment should more robustly protect economic liberty, and whether some of the cases that we're talking about here today should in fact be run under the 14th Amendment as opposed to the First Amendment. Okay. As you're all aware, Lochnerism was an obstacle for New Dealers attempting to build out the administrative state in the face of some of the challenges of the Great Depression. But after FDR threatened to change the size of the Supreme Court in 1937, the court repudiated Lochnerism in West Coast Hotel. And since then, it's been relatively black letter law that economic regulation is subject only to rational basis reviews, the lowest level of review that provides the greatest discretion to the political branches to regulate how they will. Which is to say that the court, in the turn of the New Deal, largely foreclosed robust economic liberty claims under the 14th Amendment, okay? And that's part of what we're seeing now today. So you might ask, I've been talking about the 14th Amendment a while, what was the First Amendment doing during this time? So fascinatingly, which I don't know, I was surprised to learn when I began studying this stuff, First Amendment jurisprudence is actually really quite young, and protection of commercial speech at all is very, very young. In fact, within the lifetimes, I would say, of the vast majority of the people in this room, other than like the law students, okay? So the founding generation passed the Sedition Act of 1798, which made seditious libel a federal crime. Okay, you all know this from law school. As Akil Amar has explained, the Supreme Court justices writing circuit 2 centuries ago cheerfully enforced a sedition act that made mere criticism of certain incumbents a federal offense. So our current cultural understanding of the First Amendment, that it's this robust right, is relatively new in many ways. That I think that's great, but that's also just to give you some background. The Supreme Court, in fact, did not address a single free speech claim until the early 1900s, and those cases were all about political speech, okay? And in the early 1940s, as I think Eric said, just after the court's turn away from Lochner, it outright rejected the notion that the Constitution protects commercial speech at all, okay? It wasn't until the 1970s, and I think really interestingly, at the insistence and asking of public citizens, so the progressive consumer rights movement, that the court extended any protection to commercial speech at all, in this case, Virginia Board v. Pharmacy. At that time, any scrutiny was extended to commercial speech. Justice Rehnquist and the conservatives on the court found that disconcerting and called any protection for commercial speech a form of dangerous judicial activism, okay? So that's, again, 1976. So, okay. But beginning in the 1990s, that began to change as justices, including I think probably most prominently Justice Thomas, began to see the First Amendment as a robust protector of economic liberty interests. And since that time, again, since the 1990s, these cases have been rapidly proliferating and claimants have become more successful in, I think, two important ways. One, the commercial speech doctrine has become stronger and stronger, so the level of protection that you get under Central Hudson has increasingly moved towards strict scrutiny, and at the same time, the number of things that we think of as potentially implicating the First Amendment has radically expanded, such that today, a claimant bringing a claim that like baking a cake is a fundamental First Amendment speech interest goes to the Supreme Court. Okay. But that's true not just of things that you've heard about, but everything from cigarette warning labels to credit card swipe fee laws to the FDA's drug regulatory power to anti-discrimination laws. Essentially, we're seeing a proliferation across the circuits of challenges to what a generation or even a few decades ago we would understand to be economic regulation, challengeable only under rational basis review as a First Amendment issue. Such that I think it's no overstatement to say that the First Amendment has emerged as a really robust form of constitutional deregulation, and one I think that of profound importance to modern governance and to American, both economic and social life. And what's fascinating to me as an academic is that those kinds of cases didn't exist even a few decades ago. But now all the major appellate firms across the country have robust First Amendment economic practices. This really emergent and revolutionary turn was brought about through the mobilization of the business community through a form of what I call a social movement, including, I think most prominently, the U.S. Chamber of Commerce and its really spectacular litigation center. I don't know those lawyers, but they're really good, as well as the Business Roundtable. And thanks in no small part to a memo offered by Justice Lewis Powell just a few months before he was elevated to the Supreme Court. He had a friend who was the head of the Virginia U.S. Chamber of Commerce, and he wrote a memo essentially saying that the left has been really successful in doing certain types of litigation and organizing. So like the consumer movement, the NAACP, the labor movement, they do all of these things to try to change what the courts do and what the government does, and the business community should do the same thing. That's what's happened to enormous effect in many areas of law, but particularly our focus today in the First Amendment. So many of the folks who were originally interested in saying, Lochner, the overturning of Lochner was wrongly decided, the 14th Amendment should protect economic liberty, have now moved into making arguments about the same types of claims but under the First Amendment. That was originally criticized or questioned by a bunch of people actually in the Reagan administration as being self-interested as opposed to being principled, and we can sort of ask some of those questions. But regardless, the movement has been profoundly successful. The First Amendment is increasingly marshaled by plaintiffs across the country to review, again, what we might otherwise understand as ordinary economic regulation, and bringing with it the First Amendment's intermediate or even stricter review. So let me give you a couple of cases just, it's amazing the number of cases that are proliferating, but the Supreme Court last term. So again, the Supreme Court didn't consider any First Amendment cases till the early 1900s. This term alone, it's granted 3 cases involving these sorts of issues. Last term, it considered whether or not credit card swipe fee, regulations of credit card swipe fees laws. So if you buy something with a credit card, the credit card company charges an additional fee for your using of the card, but the credit card industries have lobbied in the face of folks like Elizabeth Warren, don't like these laws, to say, no, you can only you have to charge the same amount to credit card and cash fee folks. Those laws were challenged under the First Amendment, went all the way to the Supreme Court, where the question is whether or not a difference in the price is a type of protected First Amendment interest. Okay. In addition to those sorts of cases, we see Masterpiece Cake Shop, involving whether or not baking a cake is a form of expression. There's a case later this term about public sector agency fee laws in the union context, and also a challenge to mandated disclosures for crisis pregnancy centers. So these are kind of the flip side of states that want to discourage abortion through requiring women to get ultrasounds. California has a law that says certain types of centers that don't have doctors have to provide certain disclosures. But I could give you dozens more examples. Cases like this are proliferating around the country. And as Floyd Abrams, a prominent First Amendment Supreme Court advocate, said in a debate recently, more so perhaps than at any other moment in history, the basic purposes of the First Amendment are now in play. So the important points here are that the First Amendment protection for any form of commercial speech is actually quite young, but it's now hotly contested across the circuits, due in no small part to the success of what I think is of this like business-led social movement. Okay, so that's a bit of how we got here, and now I just want to raise some questions for you all about what it means and why it matters and where we should go from here. The first is to ask if there's anything distinct about protecting economic liberty claims under the First as opposed to the 14th Amendment. So if you hang out in progressive circles, a lot of people will say, like, look, this is a new form of Lochnerism, okay, with a lot of hand waving. And so what sometimes I wave my hands, okay. But, you know, in fact, so like Supreme Court justices from Rehnquist to Breyer and a growing number of scholars have drawn parallels essentially between the Lochner era form of protection for economic liberties and what's happening in the First Amendment today. And I think it's obviously true. There's some forms of parallels, right? They similarly bring the Constitution to bear on economic interests, and so in a way transfer substantive decision-making about economic affairs from the political branches to the judiciary, right? We can talk about it, so that's a good idea. But there are also really important differences, and I think to just convince upon you that what's happening in the First Amendment is something really new and important. They have different scopes. So old economic liberty claims in the 14th Amendment were really about the right of contract, right? But the right of free speech is actually much broader than right of contract. And since the time of Lochner, the understanding of a right has become more robust. So when you invoke a constitutional right, you don't get a balancing type test very often, like you would under Lochner. You get something that looks more like a Dworkinian like hammer, right? And that's a big deal. So you get something better today under the First Amendment than you would have gotten with a similar type of claim under the 14th Amendment. They also have different theoretical baselines, okay? So the 14th Amendment Lochnerism was like understood to be protecting an understanding of laissez-faire capitalism under, and freedom, a certain understanding of freedom under the 14th Amendment. Today, that's less the idea. Instead, it's this idea that like speech is speech. We know it when we see it, and we should protect it with. Like, it's the same thing. Like, there's no distinction in the Constitution, Christina says, between commercial speech and political speech or any other type of speech. So it should all just get the same level of review. I think there are a couple things that's interesting about that. That sort of like openness. No kind of like real clear theory allows this sort of litigation to trade on a mid-century coalition from the ACLU and Public Citizen to like Cato and the Religious Right to support this litigation. But also by anchoring itself in the First Amendment, it allows, it sort of like, there's a textual hub for the First Amendment for these sort of claims that's different than bringing an economic liberty claim under the 14th Amendment. But the upshot of it is that it means that these sorts of claims to rest on essentially what's the obviousness of whether or not something's speech versus, as Eric said, whether or not something looks like conduct. Okay, so those are some of the parallels, but the basic question that we might want to ask is, should a lot of economic liberty claims run under the First Amendment? Why are they running under the First Amendment? Or instead, should they be 14th Amendment liberty claims? Okay, second, I want to raise some questions about constitutional change. So a bunch of progressive scholars, often called democratic constitutionalists, like Jack Balkin, for instance, you may have heard of, Ariva Siegel, have published scholarship about the way that social movements, like the women's rights movement or the gay rights movement, have created constitutional change. So have changed the court's minds about what the Constitution means. But the story of the changes in the First Amendment and how it's become a hero of economic liberty suggests as a descriptive matter that constitutional law is in fact significantly changed by social movements, and not just of like the progressive or identity politics variety. Recent changes in the First Amendment, as actually a leader of the FedSoc conference at Georgetown Law School where I taught a course last semester said, maybe makes one of the best cases for living constitutionalism. But this really raises fundamental questions about what sorts of constitutional change are legitimate and why. And we might come out differently, or originalists might come out differently than libertarian folks on what's happening in the First Amendment today. So this takes me to my final sets of questions, which are pretty conceptual and basic about the First Amendment. But it goes to what I think sort of high stakes of the developments in the First Amendment case law today. So that's based on the fact that speech is everywhere. Nearly everything that humans do involve either the spoken or the written word, or could be understood by another human being to express something. So for instance, like, I protest I don't like speeding, I really like speeding. I protest speeding laws by speeding. And I'm expressing that I don't like speeding laws, okay? Or you can think about something really obvious like 9/11, right? We all can understand what was the message of 9/11, right? Or for instance, a refusal, I'm from Atlanta, a refusal to sell a sandwich to an African-American person in the 60s, right? That's a pretty expressive, or to sell a cake to a gay couple today, right? All of which could be argued in some even plausible sense to express something. But for that reason, the First Amendment could at least theoretically be invoked to oppose nearly any form of regulation, economic or not. And if the First Amendment covered with this type of like strict in theory but fatal in fact scrutiny, it would render governance literally impossible on a range of types of things, including things like commercial fraud or the regulation of public schools or criminal fraud, right? Those are things that it's speech, right? So it raises these important questions and also the stakes of the current transformation or securities fraud kind of in the First Amendment today. Okay. So let me just talk briefly about fraud. So in 2011, the Supreme Court had a case called Alvarez, you all may have heard about this guy, and he falsely said that he had won some military honors that he had not in fact won, and he got in trouble because there's a law that says you can't lie about military honors. And the court basically said, look, actually, lying essentially in political life is important. We need to give breathing room to the First Amendment, including for people who intentionally lie. But this raises some important questions. If we divide any kind of distinction between the political sphere and things like commercial fraud, it's possible we'll be in a world where securities fraud, commercial fraud, other types of things that I think intuitively we think probably the First Amendment shouldn't protect with fatal in fact review, or we may be moving in that direction. So that's just one example, but we can think of tons more. But the basic question is, we have to realize that because of the pervasiveness of speech and expression, that we need to think really seriously about what the limiting principles are and should be, not just within commercial speech law, but in these other domains. And that it's not enough just to say, well, speech is speech, so we should give it strict scrutiny, but we have to have a sort of broader theory, particularly given the history of where the First Amendment has come and where it should go. So that's what I got to say to you. Excited to hear your thoughts and questions.
All right. Thank you to our panelists. Before we take some questions from the audience, I want to exercise my prerogative as moderator and ask the first question. And this is more geared toward answering one of the questions that Amanda brought up. I wondered if the both of you could comment just briefly on this perhaps growing trend of bringing challenges to occupational regulations as speech cases rather than, say, 14th Amendment cases, and perhaps even a trend of bringing cases about fraud as covered speech cases. Do you think that this is a growing trend, and when is it more appropriate to bring these types of cases, say, under the Due Process Clause?
So, yes, it is a growing trend, and I definitely agree with Amanda that there is a, shall we say, innovative use of the First Amendment, growing reliance on the First Amendment to challenge what decades ago would have been considered traditional sort of commercial regulations, and getting to the Speech Act distinction that Eric referred to. Sometimes it's hard, but in the credit card swipe fee case, for example, that Amanda talked about, it's important to remember this is a case last term called Expressions Hair Design. The point of the rule was a prohibition on disclosing to consumers that if you use a credit card, you pay 3% more than if you pay cash. And yes, that's part of a commercial transaction, but the point of the rule was the credit card company lobby didn't want people to know that you paid more if you use a credit card. And the only way they would know is by disclosure. So it's kind of like Virginia Board of Pharmacy. You're trying to suppress information to the public. So there's no doubt that there is a speech interest if you want to marginalize the merchant speaker. At least the public clearly has a First Amendment interest in knowing the truth. So, I agree as well that perhaps the lingering fear of being accused of Lochnerism is part of the reason why judges don't go all the way to strict scrutiny for commercial speech. That's just sort of armchair psychology, perhaps, but it doesn't necessarily follow in that case that the 14th Amendment is a better vehicle than the First Amendment for me.
Well, I guess what I would say is that I don't think you are watching the First Amendment being used to challenge economics. What you are watching is a realization that much of what passed as economic regulation was actually manipulation of the population's views and beliefs and information sphere, which I don't think of as economic in the normal sense of the word. I will not let you buy marijuana. I will not let you buy heroin. I will force you to charge the same price for a credit card transaction versus a cash transaction, whether it's for gas or something else. That is what I think of as regulating conduct. And if you ask, the bigger question I would ask is, why is there a difference between regulating speech and regulating conduct? And Amanda's question, I think, goes exactly to that. Maybe there shouldn't be. Maybe we should have a robust 14th Amendment or a weakened First Amendment, and they should be equivalent, that economic liberty and intellectual or speech liberties should be protected similarly. I think there's a reason for a difference. I think speech is more important than conduct, in the sense that speech allows us to influence and change and debate the conduct regulations, and it is necessary for decision-making, which can or can't affect conduct and will change conduct. But that regulations of conduct, they are immediately felt by the people subject to them, and hence the political process can work more effectively to counteract them when they're abusive. If you tell me I may not buy marijuana, I understand the consequences of that, and it bears upon my daily life. If you tell someone else they can't talk about marijuana, I may never know. I may never hear their voice. I may never hear the debate on whether we should or shouldn't have medical marijuana in California or DC or Colorado. And so I think there is a good reason to treat speech differently, and then what we've seen recently is the recognition that so-called economic regulators have actually not been regulating economic behavior. They've been manipulating the information sphere to bypass the political consequences of actually regulating behavior in a way that would manipulate the public mind and public opinion. And I find that grotesquely offensive, and I'm pleased by all of these cases because they're a pushback on that blurring of the difference between speech and conduct, which is exactly why I sort of advocate an O'Brien-style test, which more clearly distinguishes between expressive content, expressive behavior, and the underlying substantive behavior that's being regulated.
Amanda, would you like to respond to any of that now? Okay, all right, let's take some questions from the audience. I believe we have volunteers with the microphone, so please wait till the microphone comes to you.
Daniel Crow, Oregonian. This is a question for Bradley. Is what result if instead, speaking of the prohibition on advertising guns, what happens if the gunsmith puts up, instead of putting up a censored, what result do you think if he puts up a sign that says something along the lines of, handguns are your constitutional right, or buying handguns here is your constitutional right? Is there any distinction between those two? And what's kind of the implication there of the kind of commingling of expressive conduct and advertising?
Well, actually, maybe that should be directed at Eric, given his remarks about the combined purposes. But I think handguns purchased here would inform the public that handguns are available for sale there, and so strictly reading the rule, it would violate the rule. But to be able to use the sign to advocate generically for purchasing handguns, obviously that is a type of speech on public policy. I don't have much doubt as to how the Attorney General would interpret that speech, given that it's occurring on the side of a firearms store.
The one thing I'd add to that is, this problem comes up in political speech too. Right when McCain-Feingold passed, I wrote a monograph that started with the statement, John McCain is a fascist who wants to take away your rights, and if I said this a few months later during the election, I'd be breaking the law. And so the fact that you invoke the Constitution to make your point, even in the political context, often gets you in trouble. Now, of course, I think it shouldn't. I thought that law was unconstitutional, but, sometimes even strict scrutiny is not fatal. Or sometimes it's just not strict. So that was all I'd comment on that.
No, I mean, I agree with you all that I think that type of, I think it's unlikely probably that a regulator would think that that would be regulable, but also I would imagine that it would be protected under Central Hudson or any other standard, but maybe not even Central Hudson, something stronger. I think one of the interesting things, so like in Masterpiece Cake Shop, right, they got, the bakery said that they didn't want to sell a cake to a gay couple because that would express something. But then there's also a question of like, could you put up a sign, for instance, that says, you know, God disagrees with gay marriage, and like, could that be regulable under anti-discrimination laws? I think there will increasingly be cases like this that will be coming to the courts in a range of different kind of like subject matter contexts.
All right, let's take another one.
Duff Sunheim, I think we're talking about the interaction between different rights in the Bill of Rights. And it seems to me like if you look at the cases, there's kind of a flow, and we're talking about whether the flow tries to take on too much in any one area. And I think the Masterpiece case, if you listen to the oral arguments, there was a lot of concern about whether this was really a First Amendment case rather than a religious liberty case because of the employment Smith case that came out and said, okay, if you're treating everybody generally. Is there a feeling amongst you that we have gone too far in the First Amendment relative to the religious liberty, and we should re-examine the religious liberty rights?
So I think that this is true not just in the religious liberty context, but in a bunch of contexts. Essentially, like, because the First Amendment, because speech, like I said, is like literally everywhere. You could argue anything that you do as an action is expressive. It means you can invoke the First Amendment a lot of places, and when folks are closed out for whatever reason, say Smith in the religious liberty front, or by Lochner in the 14th front, or, I mean, originally how Virginia Board came is these progressive guys wanted to bring antitrust cases against the pharmacy industry, right, with consumer rights advocates, and that was closed out by precedent, and so they turned to the First Amendment. And so, you know, as we've asked the First Amendment to do more things, it's become spread thinner, and it means that we either need to come up with a lot of good reasons and more doctrine under the First Amendment about how to think about potentially very different types of questions, or we need to say, okay, no, we need to start moving these things out differently. So, yeah.
I'll just comment briefly on Masterpiece, the cake case. You all may know this, but I just want it to be clear that the facts of that case don't involve a cake sitting in the baker's on the baker's glass ready to be sold. It involves a couple saying, we want to hire you to make a cake, and here's what we want you to say on the cake. And so that's the nature of the claim, that it's expressive conduct, or artistic conduct of a sort, rather than the analogy to the 1960s in refusing to serve hamburgers to somebody of a different race.
Wait, can I actually?
Sure.
So I was fortunate to litigate that case. That's actually not true in Masterpiece. It is true in other cases, but the guys in Masterpiece who wanted the cake came in, and the purveyor of the cake, the bakery owner, said that he can't sell any cake for a gay wedding. They didn't talk about what it would look like, so it wasn't a question, for instance, of like, I want to have a rainbow cake, or I want a cake with 2 guys on it, or I want anything. It was not a question of what it looks like, but the expressive component of it was, even if it's an identical cake, if I sell it, this is like just a plain white wedding cake. If I sell that cake, all wedding cakes mean happy marriage. And if I sell it to you straight couple versus you gay couple, that has a different expressive meaning, and that's the thing that the First Amendment should protect. Right? I think that's structurally very similar to, I sell a sandwich to a white person versus a black person, that's expressive. But again, I don't think that necessarily matters for our purposes, except to say that these type of claims, like really, I don't know, novel is the right word, but we're seeing a lot more First Amendment claims about a wide range of types of the regulation of social life that we didn't see, or we saw under different constitutional hooks even a couple of decades ago.
Is this on? Yeah, good. So I've had an indirect involvement in Masterpiece as well. I actually have a different view of the case. I actually think it is the fact that it's a wedding cake that is the only thing that matters. I don't think the personal involvement of you have to do it from scratch versus you've already baked it matters. The interesting thing in Masterpiece that I found, mooting it, I mooted the advocates, was that the bake shop would have sold cupcakes or cookies or just a regular cake without no questions asked. It was the fact that it was a wedding cake, which I think is intrinsically expressive. That was the bigger and more salient point, though not the one they made, by the way. But to me, it was the more salient point. And it goes to this issue that I think speaks to Amanda's point, which is there is a blurring of the lines, but I don't know that it's with speech. I think it's with expressive association, because expressive association and economic association are almost impossible to disentangle, which is sort of why the Nike case comes up, is I don't want to associate with you. I don't want to buy your goods if you're a bad person, because my mere buying your product is an expressive act, and I therefore want to dissociate myself. And so that is really where the blurring is happening, and Masterpiece is probably a good example of that blurred line, in that the baker did not want to associate with an event that was contrary to his beliefs, and it had an expressive component because it was a wedding cake, as opposed to because it was a bunch of cookies or something, which I think they conceded. They'd sell cookies to anybody who wants it, and you want to buy cookies and take it to your wedding, go right ahead. It's that a wedding cake is more expressive, perhaps much like a painting. I mean, if you would pause for a moment and ask yourself, what about the person making a custom painting? Can you say, no, I'm not going to paint the couple in a gay wedding, but I only will in a straight wedding, or vice versa, right? I mean, it doesn't matter which way you go on this. It would be discrimination, presumably. So that, to me, is you should focus on association more than the growth of speech conflicts.
So I think that, can I say one thing? I think that's really insightful in many ways. So, well, as a factual matter, they also wouldn't sell cupcakes. Wouldn't sell cupcakes either. Wouldn't sell any baked good for your wedding, but they would sell you anything else for any other event. Okay. But again, I don't think that matters here. But the one thing that's fascinating, though, to me, is that those types of claims, like I don't want to associate with you in economic life, right? So we had like Heart of Atlanta Motel, where I'm a motel person and I don't want to have black people stay at my motel. Those were run under the 14th Amendment, true Lochner-style claims, okay? Then in the 80s, we saw them as association claims. So this case Hishon, in which King and Spalding, I think, said that they didn't want to have women partners. And they said, I have an associational right as a law firm to not associate with women in professional life. And the court said no. Okay. And now a similar type of interest, an associational interest, is now being run as a speech claim. And so the point here is just that, like, what we see is constitutional migration into particularly the speech clause of late.
All right, we have time for one more question. Putting all the pressure on you to pick.
Getting away from the cakes case, I wondered if anybody on the panel would comment on another area that's often confused with commercial speech, and that is professional speech, speech by professionals to their clients, which is often treated by lower courts as merely behavior that the state can control, even more broadly than it could ordinary speech, leading to the bizarre paradox that trained, licensed professionals are more restricted in their speech than untrained, unlicensed laymen. The most recent pronouncement on this is from the 11th Circuit in the Dox versus Glocks case, which I will confess I have not read. So I was interested in if the panel has any comments about that and the direction in which that is going.
Is Paul Avalar here? Paul could maybe answer that question. Yeah. We're litigating a case in California involving that, and I'll just note that, as Amanda suggests, and Christina wanted to lead the conversation earlier, there are a lot of those challenges on the way.
Well, and the court just granted cert in one of them. So the NIFLA, what does that stand for? The NIFLA case, the Pregnancy Crisis Center, raises this professional speech question about, like, what level of review? Is it the same as Central Hudson? Is it political speech? And so we may see, in that case, I think there's a high likelihood that the court will speak to this, because the circuits are all over the map in terms of how they treat professional speech.
The only thing I'd say is I think it's a species of commercial speech to the extent we're making those dichotomies. There are instances where it would be blended speech, obviously, if you're an attorney who's advocating on behalf of a client for a political cause. I think you could easily see that as an example of blended speech. But at the end of the day, I've long been of the view that the First Amendment should apply pretty strongly in those situations, and I pare back the leniency without hesitation.
Oh, one other thing I should say about that, the professional speech is really interesting because things like malpractice, we generally don't fall outside of the First Amendment altogether. Like there's no, like if I tell you like, you should get this surgery and you shouldn't get that surgery, you can sue me and I can't be like, oh, First Amendment, right? Like that's crazy pants. Okay, so it's interesting, which is I think where the court's inclinations are to say, oh, maybe this is professional conduct. But also I actually think that the professional context raises some of the kind of like, we'll show you that they're very, the ideological valence of the First Amendment, it's across the map, right? So the case that the Supreme Court took is about a California law that requires pro-life centers to post, for instance, if they don't have a doctor. So that if you are a woman and you Google crisis pregnancy or whatever, and you think it's a Planned Parenthood, but it's not, then you know there's no doctor there, okay? But at the same time, there are states that require women to get ultrasounds as a way, the state is trying to encourage the women not to get abortions, okay? Presumably, the principles of professional speech in those two contexts will be the same, which is to say, like, how you might think, if you come at this from a kind of like more religious conservative perspective versus a more libertarian perspective, you may come out on the map differently when you think about what the First Amendment should do in the professional context.
Well, let's join me in thanking our panelists today, Brad, Eric, and Amanda. Thank you very much.